The Fourth Amendment states, "The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized." The founders' decision to include this amendment in the Bill of Rights was influenced by established English law, as well as recent events that they had experienced in the American colonies. One particular case in English history stands out as setting a precedent for the Fourth Amendment. This case is Intick v. Carrington, which occurred in 1765. The authorities had broken into Intick's house and seized all sorts of documents. Although the authorities actually had a warrant in this issue, Intick sued because the warrant did not specify what specific documents were suspected to be criminal in nature. And it also did not demonstrate probable cause, nor did it make a record of what had been seized. The U.S. Supreme Court would later claim that this case served as a guide in writing the Fourth Amendment. But the founders also had personal experiences that drove them to include the Fourth Amendment. Smuggling was a very common practice in the colonies, and the British kings often issued what are called writs of assistance, which were general warrants that allowed authorities to search any house or other place to seize prohibited and uncustomed goods, as they were called. These writs could remain in force for the lifetime of that particular king. The fact that the king could authorize such broad searches of any house at any time and the seizure of any suspected goods no doubt influenced the colonists to include the Fourth Amendment. While it is generally understood that law enforcement must obtain a warrant to enter and search a private residence, there is an exception which has been the subject of extensive litigation and debate over the years. Can law enforcement search and seize the property of someone already being arrested? The Supreme Court has seemed to flip-flop on this issue over the years. For example, in Harris v. United States in 1947, they did approve a warrantless search of the apartment of a man who had been arrested. But in another case, just 1 year later, the court set aside evidence that had been seized in a warrantless search that was also pursuant to an arrest, ruling that law enforcement must still secure a separate warrant. In the decades since, the Supreme Court has upheld more warrantless searches according to various exceptions, usually if there is probable cause or if they are deemed, quote, reasonable searches. For example, administrative searches, which are searches carried out by non-law enforcement authorities, such as in public schools, government offices, prisons, etc. These have been upheld by the court. The court has also upheld some more controversial exceptions, such as those supported by the, quote, plain view doctrine, which allows law enforcement to seize any objects that are in plain view without having a warrant. Law enforcement may also search most vehicles without a warrant. According to the court's decisions, a vehicle travels in public and therefore is in plain view. The main issue in these various cases over the years involving the Fourth Amendment is how to balance a person's right to privacy and personal liberty with the need for the government and its officials to regulate and protect the society at large. Although there have been many exceptions made in the interest of the latter, the Fourth Amendment remains an important protection against broad searches and seizures by government authorities.